Hello, our beautiful friends. Happy, what is it? Thursday already.
Thursday.
Oh my gosh, time really flies. Happy Thursday, everyone. This is Lenka and Doug, and we are continuing in our series. So today we will be continuing about exposing more of this fraud that we've been tricked into. So welcoming you all. We will just wait for a few moments for people to join in. Great to have you, and we love you, all your naysayers, Yeah, it just takes a lot of guts, to truly start comprehending what we are talking about, start asking questions, start connecting the dots. It's not easy. There is a lot of cognitive dissonance. So I just love when people like to comment and, troll and numbers and everything. This is not popularity contest. This is not beauty contest. This is just free education that we provide. You can take it, you can leave it. It's completely up to you. It doesn't make a difference to us. Actually, it does make a difference to us because the sooner you enslave, you leave the tax farm, the better we all will be, but it's completely up to you. Some people just like to be tax slaves on a, free range humans on a tax farm. So anyway, welcoming you all on this lovely Thursday afternoon. It's April 6, 2023, 3:15 in the afternoon in beautiful sunny California. The spring is in full flow. We have beautiful flowers everywhere. Birds are singing. Sometimes we have lots of chemtrails, but you need to rise above that. We know what they are doing to us, but they cannot get us because we are unstoppable. We are unshakable. We are eternal beings, and we will prevail. Anyway.
It's my nap time.
Welcoming you all. So I see some people joining in. So guys, today we will continue on our discussion about mortgage fraud. Many of you have properties. You think actually that you own the property, and many of you think that you got a loan. So if you haven't watched our part 1 and part 2, please make sure that you check those videos. They are posted on Facebook here, also on YouTube, until they take us down. So anyway, today we will continue. So in our first video in part 1, we pretty much discussed kind of the overview of the mortgage fraud. What happens actually here, I have a copy of one of my promissory notes. Okay, so the application is actually, that's what sets the commercial instrument, and then the note is created here. And what I wanted to actually show you is here, it's actually says it's a stamp here for deposit for pay to the order of Ohio Savings Bank, and there you have it. Okay, so this note is that's the cash.
Let's stop for a second there. Okay, it says pay to the order of, right? Mm-hmm. Okay, what are they paying?
I know, what are they paying?
I mean, they have a piece of paper with their signature on it. Mm-hmm. What are they paying? Mm-hmm. How are they paying? That's a commercial instrument. Mm-hmm. Mm-hmm. Can't be a debt instrument, can it? Because you can't pay a debt with a debt. Mm-hmm. So it has to be a positive instrument. It has to be something that has cash value.
That's right.
And to deposit it, what are they depositing? Mm-hmm. They're depositing a commercial instrument with cash value, correct?
That's correct.
Into an account, correct?
That's correct.
Okay. So a CPA could trace that deposit, correct?
That's correct.
Okay. Now, some account, a check comes out of. That goes right to the seller. Mm-hmm. Mm-hmm. All right. Do you ever touch that check?
I don't remember if I ever touched a check, no.
Did you ever play with that deposit?
No.
Did you ever see that deposit?
No.
Okay, well, if you go look up what a loan is, the very definition of a loan is somebody loans something of substance, of value, of theirs to you, for which you owe them to pay them back with interest, because there was an actual loan. If they didn't have an account that had something of substance of theirs in it, that they let you take full custody, care, and control of, there was never a loan by definition. Okay? So let me plant that seed in your head and see what grows out of it. Go ahead, Lincoln.
Well, are we going to go through...
Yeah, we've got the memorandum. It's you can find it. It's in the memorandums book by Americans Bulletin, and I'm not promoting anything for anybody or anything like that. I don't get paid. But this is where I found it. Okay, a lot of the materials that I use come from way back in the old days. They come from the Montana Freeman, Hartford Van Dyke. I mean, I can go on down the line, you know, and they still work. It's when people take the original stuff and try to add their shit to it and break it up into sections instead of doing the whole program, and then try to sell each section as a separate entity to make money and become a patriot, Paytriot. Well, that's when you start running into problems, because you don't have all of the information that you need to make a decision on how to utilize that information in that process. You've got a piece of the process that you use, and then you're looking for the next piece. So what we want to do is we want to talk to you today about basically your remedy. Okay? We've got a process that when you get done with it, it's an administrative process. It's called a private administrative process. And when you're done, you have what's called an accounts receivable. All right? Now, when we go over this memorandum and discuss it, what we're going to be discussing is how everything is a commercial lien in this commercial world. All right? Everything that you do and that you utilize throughout the day basically deals with some type of a commercial lien. Okay? Well, what an accounts receivable is going through the tort process and making a lien. Okay? And then following it through and giving it a 90-day perfection. All right? And then what you have is a collateralized debt obligation. Okay? Because your lien has collateral that backs it up. That collateral is now yours, according to the UCC, starting at 9609, and you go to 9619 to get a transfer statement. Put that seed in your head for a minute. Okay, so now you've got these people in default through your tort process, and you bill them once a month for 3 months. Okay, tort process is your private administrative process that makes the claim. The 90-day perfection of the claim is the one billing cycle. All right, because this is going to come up in this memorandum as Linka reads it. And what we need to do is as we go through here, we'll sit here and discuss it and discuss what it means. And that way you can comprehend how you can use your private administrative process, get it complete and perfected, and be able to make UCC money of exchange, okay, through this process. And if they fail or refuse to take your offer of this money of exchange or assignment, well, then they violate the tender of payment laws, and it's discharged up to that point. That's right. So this is what we want to go through with you, because it pertains to not only mortgages, but it pertains to almost any other debt that they try to place upon you. Okay? And it also shows you a way that you're able to go on the offensive against these public mercenaries and public pretenders that want to call themselves government, or say they're a corporation, depending on what side of the bed you catch them on. All right, so let's go through this memorandum, and by the time we get done, maybe you'll have a good comprehension of how things are done with your signature,
and how money is made,
and how money is created.
Yep. pretty fascinating stuff. So prior to 1938, all U.S. Supreme Court decisions were based upon what termed public law.
Don't you just love her accent?
Or that system of law that was controlled by constitutional limitation. What are you talking about? It's very American. After 1938, all U.S. Supreme Court decisions are based on public policy concerning commercial transactions made under the negotiable instrument law. As a result of the U.S. bankruptcy as declared by President Roosevelt on March 9, 1933, and codified at 12 U.S.C.A. 95A and by executive orders. This bankruptcy caused the change from public law to private commercial law and was recognized by the Supreme Court in Erie versus Tompkins, 1938. After that case, all the procedures of law were officially blended with procedures of equity.
Now, stop there for a second. If everybody goes and looks, I think it was around the 60s, maybe before that. But if you go and look, you'll find where your court system combined law and equity. Okay, there's only one form of pleading, okay, and they combined all of that into one form. And what that does is if there's only one form of pleading, well, these so-called administrators can get up in the middle of court, walk out, and come back out and start a whole new court without even telling you. So you might be in law at one point, admiralty, okay? And if they can't beat you at admiralty, recess, get up, leave the courtroom, come back in, start a new court. Now you're in equity.
Mm-hmm.
I mean, it's that simple. They blended everything together. Each jurisdiction, well, not jurisdiction, each law is separate in itself. Equity is different from admiralty. Admiralty is different from common law. Common law is different from equity, and you can go all the way around in this circle. They're all separate, so you can't have all of them at once. You know, but they're also required to tell you the nature and the causes of the charges or the actions against you. Okay, and so this is where they get you. They blended it all, and it became basically the commercial law, or the UCC actually became the federal common law. There's a few court cases that say that. All right, they can't apply the common law of the state or whatever that you're in, being that they're federal, and federal has no common law. So the common law that they've taken up is UCC because everything is in commerce.
Mm-hmm. So the negotiable instruments law is a branch of international law merchant, which is now known as the Uniform Commercial Code, the UCC.
Imagine that.
That was drafted and made uniform and adopted in whole or substantially by all states. Black's Law Dictionary, 6th edition, page 1531. Thus, the several states were and are bound into commercial agreements to the federal United States under the Uniform Commercial Code. And the several, now 50 states, accepted the benefits of federal grants offered by the federal United States as the consideration of commercial agreement between themselves. Under the agreement, the States Conference of Governors, which happened on March 6, 1933, pledged their full faith and credit and agreed to obey the dictates of Congress and assume their portion of the national debt collected as your fair share, as an example in the nature of the unlawful income tax, wherein the IRS operates and collects such taxes under the same UCC. And this system of negotiable paper has bound all corporate entities, cities, counties, municipalities, etc., of government together to the process system of the commercial venue of commercial law as expressed and exercised within the commercial lien process. This nationwide commercial bond also altered the original law status of the courts to nothing more than administrative tribunals merely administering the bankruptcy private policy of debt collection for the creditors.
Okay, let's stop here for a minute. What that's saying is that everything, okay, is been placed into commerce. these municipal corporations, all right, that are acting as our government, okay, are in violation of the Clearfield Doctrine. When they took the money and started using the negotiable instruments, because there is no money, all right, and House Joint Resolution 192, Public Law 7310, they placed all of the people, they put everything, the full faith and credit of all of the people in all of the nation up for collateral behind the debt. Okay, that they said they didn't need any gold or anything backing the debt because the full faith and credit of the people backed it. That's when they came in with the birth certificates and pledged us as collateral, stock of that corporation.
That's
and if
right.
you're rich, you're preferred stock, and if you're poor or middle class, you're common stock.
You mean who has more of the death notes?
Well, you know, what they do is they value you through your vital statistics, okay? And what I mean by that is you have the United Nations, the International Monetary Fund, and the Pope. And the Pope actually runs everything, and I'm not talking about diarrhea. He holds everything through the IMF and the UN and the NATO countries. So all NATO countries have what's called the civil registry that goes right into the UN. And the birth certificates and everything that goes through vital statistics are registered in that civil registry, and they're marked in your individual master file and a few other files that they keep on you. And so the vital statistics, the certificates you got, the things that you graduated through, the things that you've completed in life, whether you're married, or whether you're a doctor, that rates you as far as preferred stock or common stock, and it rates you as far as your standing and your value within the Siesta KV system.
Okay, great. Through the bankruptcy, no, we lost the document. Let's see here. Some notice came here. Through the bankruptcy, the UCC and other acts, Congress in failing to uphold its constitutional duty to provide a lawful medium of exchange, i.e. money backed by silver and gold or minted coin pursuant to Article 1, Section 8, Clause 5, have by these various acts created an abundance of this new type of money called commercial credit money to circulate within the legislative democracy called the United States, of which they are not bound by constitutional law and limitations. The commercial law venue compelled upon the people enforced benefit of limited liability for the payment of debt by the use of Federal Reserve notes, which is debt instruments, wherein your debts are only discharged, not paid, in the form of interest-bearing negotiable instruments, Federal Reserve notes. There is a distinction between a debt discharged and one paid. When discharged, the debt still exists through divested of its character as a legal obligation. Staniek versus White. Federal Reserve notes are only evidence of a debt owed to the Federal Reserve Bank, and Federal Reserve notes are commercial lien on the Federal Reserve Bank. Since 1933, by the acts of the bankruptcy and the UCC, the law has been tainted or color of law, as it were, because the commercial law is operated in conjunction with the negotiable instrument law, wherein the federal government, by and through the bankers, can have declared that a piece of paper which the Federal Reserve Bank of Chicago, in its publication Modern Money Mechanics, page 3, has in fact declared the use of these debt instruments, Federal Reserve notes, a confidence game. The substance of the law property, meaning gold, silver, etc., has been removed, like the substance that is the basis of money. Accordingly, law like money becomes a fiction, make-believe. Therefore, in the USA, by and through the UCC, all contracts, agreements, implied or otherwise, applications, permits, where the colorable consideration, Federal Reserve notes, was passed in those contracts, all such contracts are then also colored and are not genuine, for no lawful consideration, gold and silver, was paid by either party to the contract to, by law, pass both the possession and the property to the lawful buyer. See Bouvier's Dictionary of Law, 1839, title definition number 5. The lawful coin of the United States will pass the property along with the possession.
Yep, let's stop there. Okay. What they're saying there is you've never really bought anything in your life because you've never really paid for it. And even when you discharged the obligation that you would have towards that debt, it wasn't discharged with anything that you owned. So even though you used Federal Reserve notes to discharge it, well, the Federal Reserve is the one that had the interest in that, whatever it was that you bought. Mm-hmm. And, you know, through the state, you were a mere user.
So today, all our courts sit in non-constitutional, non-Article 3 legislative tribunals administering the bankruptcy through their status, which are in reality commercial obligations for the benefit of privilege of discharging your debts with the limited liability of the Federal Reserve monopoly callable money notes. Under the current colorable legal system, de facto, we just do it, legislature has created colorable rights called privileges, imposes duties, lays down rules of conduct, and the legislative tribunals declare the same as rights. These privileges are granted and given upon the people's voluntary act of asking permission, there you have it guys, then upon providing any colorable consideration payment which equals discharge. The people then come under the administrative jurisdiction of commercial law. Today in America, everyone, all governments included, are statutory law merchants dealing in negotiable paper instruments under the UCC for the limited liability for the discharge of debts wherein a debt remains a fraud and nothing else. The so-called judges are operating only a commercial tribunal to administer their corporate regulations concerning all financial transactions, both voluntary and those coerced. All debts are satisfied by one or both of two ways, a payment or a promise to pay. Every payment is by substance, and every promise to pay is accomplished by a currency or paper which is technically known as commercial lien. The satisfaction of the debt by providing substance is called paying the debt. The satisfaction of the debt by a written or printed promise to pay the debt is called discharging the debt. All debts are paid by substance. All debts are only discharged by currency, pocket money notes, or other commercial liens, negotiable instruments, commercial lien, security asset, UCC1 asset. All paper money consists of notes which declare a debt or obligation and which promise or demand payment. All such evidence of debt or obligations are technically known as commercial liens. Such notes include currency, for example, Federal Reserve notes, checks, drafts, conditional checks, notes of exchange, paper money instruments between banks. Federal Reserve note is a commercial lien on the Federal Reserve Bank. A personal check is a commercial lien on the bank account of the maker of the check. A draft is a check with a conditional agreement printed above the place of endorsement on the back side of the draft. A note of exchange is a commercial lien between the banks consisting one bank demanding payment, discharge, from another bank. A personal check while passing between banks as a note of exchange is a commercial lien. Bank accounts are backed, supported either by substance money or by paper money or by both. The substance money is called collateral. The paper money can be currency, for example, paper money notes, a loan of credit from the bank or check or other paper money such as are liens received from another sources. Therefore, the property declared, pledged, or claimed to secure the obligation and damages is the collateral by and through the commercial lien process, which establishes the credit called commercial credit money. Valid credit currency, commercial lien, can be established by making a valid claim of debt based on a damage or injury via tort claim with supporting affidavit in the form of a private security agreement and other related documents. And by allowing the lien to mature in 3 months, 90 days into accounts receivable under commercial law, by the failure of the lien debtor to contest the agreement, the lien, by answering or rebutting by his affidavit on a point-for-point basis. A lien must obtain, first, the names of the party or parties, claimants, and debtors. Second, an affidavit stating the events which created the obligation. Third, a ledger giving one-to-one correspondence between events and their values. 4, a list of property pledged or claimed to secure a payment discharge of the obligation. And 5, any evidence or exhibit in support of the claims made against the debtor. And the primary method of establishing a commercial lien currency paper negotiable instrument is to combine, first, promise to perform, second, claim of breach, damage, injury, fraud, or 3, a 90-day default to challenge or rebut the claim lien on said point-of-point basis. Commercial lien value currency can be in the form of a bank check, a draft, UCC-1 security, and its partial assignments that pass and are accepted or circulate as credit money. Therefore, the people operating in their private capacity by and through the remedy provided in the Uniform Commercial Code pursuant to their collective sovereign capacity upon injury or damage may, as a matter of rights, proceed to utilize the commercial law venue against the agents of government, their creations, corporations, and its officers. Accountability equals liability to arrive at the truth and secure damages by the commercial lien process to create and establish the damages in the form of UCC money, i.e. security and asset and liability, supported by the full faith and credit of the United States federal government under commercial law and UCC, America's federal and state common law. And in the commercial value, truth is sovereign, and the sovereign must always tell the truth.
Yeah. Now, what that just said and what she just read to you is your way of going after these people. What you do is you take that private administrative process, you get them in default. Once you get them in default and dishonor, right, you hit them with the tort. That tort, well, you hit them with a criminal complaint. All right, you file that with quit. If you wonder
With
what,
the US,
yeah, if you're wondering what we're doing, we got a little puppy right here.
Yeah, and she
decided to wait until we decided to do the video to use me as a chew toy. So
yes, so we have a little fight underneath the desk here going on.
So anyway, what it's saying is, after that you do the tort. Okay, now that right there is your claim, your valid claim. All right, the 90-day perfection is when they're talking about after your claim. What you do is you secure your claim through Article 9 of the UCC by filing a lien, and you list the collateral. All right, and then you go ahead, and from that point on, if you take the proper steps that are laid out in the UCC, that's where you go from 9609 to 9619. You end up with a transfer statement which allows you to do a non-judicial foreclosure. Or you can take all of the collateral that you have there that backs the debt. All right, you can take possession of the collateral, or you can do partial assignments of the debt using UCC3s, like a checkbook, writing checks out of the account. And that account is backed by that collateral, so it's actually asset backed and has substance to it. And so you're actually trading substance for substance and can pay a debt with it. All right. So it's better than Federal Reserve notes. And then what you do is you tender that as payment for whatever they're, like, say, a mortgage. Okay? Which, and this is how it really works. You don't like your mortgage company? Pick a fight with it. Okay? Tell them, hey, you know what? I don't think that you loaned me anything of substance. I don't think there ever was a loan. So
well, it's not
you need to prove this, okay?
It's not
because they never
picking
did,
a
right?
fight. It's just discovering that you might have been defrauded and that you
No,
like
it's picking
to
a fight because you're going to have to fight, okay? But the bottom line is you get them in default, okay? Because they're not going to show you anything of substance. They're not going to verify the debt or prove they've given you a loan. I've tried it a bunch of times, and she's tried it a whole bunch of times, and it worked out like that every time.
Still cannot verify the loan.
So now you're ahead of them because you've been paying your mortgage, right? Okay. So now you get them in default, and then, like a lawful notification letter or a writ of discovery asking for certain things, and they don't do it, right? Then you take them to the next step, which is the criminal complaint, and then you tort them. All right. Now, when you get done with the tort, okay, you've got them for a certain amount, okay, for the injuries and damages that they've caused you, okay? So that right there, you bill them once a month for 3 months, and it's an accounts receivable. You place a lien on everything that they own that's not exempt, okay? And now you have what's called a CDO. It's a collateral-backed debt obligation, all right? So you can do assignments of that collateral or partial assignments of that debt, right? And do a bill of exchange with it, okay, from that account that was created when you filed the UCC, all right, into their account or to them personally, all right? And then, if they reject it, well, go look up UCC 3603. It's called the tender of payment law. You tender them a payment, and they refuse it. Because they can't tell you what specie they want it in, okay? Because it's all the same. They're all commercial instruments. They're all negotiable instruments, okay? They're not. So it doesn't matter if it's a bill of exchange, a promissory note, a check, whatever. It's just a transfer of credit. It's a commercial lien upon whatever bank or whatever it is you're doing. And that's just what she read to you in that memorandum. And so, you can go after the mortgage company, get them in debt, get accounts receivable against them, a collateralized debt obligation, and then say, okay, well, look, I tell you what, I think it was all fraud what you loaned me, but you owe me this right here. And so I'll tell you what, I'm going to write a partial assignment of your collateral and give it back to you to discharge that debt. Okay, actually pay that debt, okay, with your own collateral. And then you just pay me the rest of what you owe me. See,
for the injuries.
For the injuries. And it puts you in that position. And if they don't do it, it's discharged. And you get to collect all of it from them.
Really fascinating. Fascinating, how we function in a debt society where we have no money. And we haven't had any money for quite some time.
Well, they took the money from us and they went into a voluntary bankruptcy. Mm-hmm. And so all of this stuff that everybody's been hearing and calling, conspiracy theories and all of this stuff, right? Well, they're not conspiracy theories. They're theories. They're not even theories. They're reality. It's facts. So, what we were supposed to do when they took our money is we were supposed to send them to where to go get the money. He who has the gold pays the bills. So the government was supposed to take care of everything for us. That's what you sign something and put your exemption. Your exemption is your Social Security number without any dashes. Okay, that exempts you from having to pay for anything. All right, or is supposed to, and so you would accept it for value, and return for discharge, and put your exemption number on it, sign it, put your thumbprint, boom, and it would go in, and they would have to take care of it. They would have to discharge that debt according to law because that was the deal that they made with everybody. But as time went on, and as these piece of shit lawyers decided that, we'll just steal everything. So if we don't tell them about this new deal and these CSKV trusts and these accounts that are supposed to
set
take care
up
of these
for people. Yep.
we can use them to run our drugs and the money from our prostitutions and sex trafficking and everything else. You know, that's what they've been doing. And they've been, you know, trafficking in persons Part B, because everything that you do, they reach into that CSKV account and they get paid. Okay, they get theirs out of it. And what you are is you're on the hook. You're a commercial vessel for the United States corporation. And what corporate county you've been docked in. Okay, and I mean docked. All right, you came out the birth canal. All right, as a vessel. So you came out of water as a vessel, and you were dry docked in the county where the dock signed your birth certificate. You know, and I mean, ever since then, you've been sold into involuntary servitude, and it sounds way out there, but these people are way out there. I mean, what kind of sick minds sit around and think up ways to screw everybody out of all of their sweat equity? Because they can't screw us out of any money. What they screw us out of is every hard asset that we earn by giving us worthless paper for it. And we think we're sitting here dumbasses thinking that, oh yeah, man, yeah, I got all this stack of all these $100 bills. That's a stack of debt you had, homeboy. The more $100 bills you got, the deeper in debt you are. You know, I mean, that's how crazy and how stupid it is. But that's where we're at. You know, and so you know what's going on now out here in the world. You're watching these banks go down, right? And the stock market's creeping off the cliff. Okay, there's no stopping what's coming. Okay, it has to go down. Everybody in the world hates us because our government's been going around, you know, basically robbing everybody, the whole world, and stealing their assets for the Pope and the Queen. All right. So, I mean, you know, this hasn't changed in, you know, thousands of years. It's the same old shit, right? But now we're going to change it. You know, now we got a chance that we can actually do something and make a change and write history for ourselves. We don't have to comply or follow this rogue government.
And definitely challenge all these frauds, you know, like the mortgage fraud, like all the unlawful taxation, and that you've been presumed and assumed to be someone you are not. You are a living man and woman. Women, you are living people. You are no 14th Amendment U.S. citizens, residents, taxpayers, and citizens, and humans, and all kinds of stuff that they are labeling U.S.
Well, look, let's take it. Go look in their legal dictionaries. You know, human being is considered a monster, right? I mean, God made man, right? All right. Hue means color of, right?
Yep.
Hue, color of, man.
Hue,
color of man. I'm not a color of man. I'm a man.
Yeah, just look up.
Just like color of law. I don't go underneath color of law. That doesn't affect me. That has nothing to do with me. You know, I live under the law. All right, and the law is real easy to live under, especially the common law. You just don't harm anybody, their property, or their rights. You can do whatever the hell you want. It's nobody's business.
And do honorable contract, do honorable business. You know, very simple, 4 rules.
Straight up business. You know, it's all of these attorneys that came over from Britain that were corrupt from the gate. Okay.
This is how they infiltrated us.
They infiltrated us, and they usurped our government. Nobody does shit without talking to an attorney. No government agency will do shit without talking to an attorney. Okay, these corporations aren't our government. They don't do anything without talking to attorneys. The attorneys run them. All right, the attorneys run the world. You know,
the bar association.
The bar association. Well, I say we bar the bar.
That's right.
You know?
We bar the bar.
Yeah, they're worthless. They're good for nothing.
You know,
they live. Think about this. Okay, you got a group of people that live high on the hog. Mm-hmm. They get paid no matter what kind of crappy job they do. All right. Mm-hmm. And they sit around and think up ways of starting controversy. Why? Because they only get paid for controversy. They stir up as much shit as they can and they stand on the side like, hey, man, I'll defend you. Well, hell, no, you don't need to. I'll defend you. Give me $10 more than him. You know? They're a bunch of two-faced, lying pieces of shit. Okay? And they've really screwed our world up. You know? If it was on me, I would have another what was that called when they went and took all them people that was Christians and stuff back in the day? What was it?
I don't
And
know.
they tortured them?
Oh, I don't know.
Nah, not a Renaissance. Anyway, I do the same thing to the lawyers. You know what I mean? Instead of witches and burn them at the stick, I say we burn lawyers at the stick. You know, have a nice bonfire.
Well, what they've done is they trick people, you know, because no one is taught law, no one is taught their rights, and so we live in belief that we have actually justice, that we have a system of law, that you know, until you get into a jam with them, and then you realize, you know, how screwed up really the whole system is, that there is no justice in the court, you know, horror stories of people going in and just couldn't believe what was actually happening. They lie, they conceal documents, they constantly trick people, and it's done on purpose, you know. All these statutes, codes, and millions of ordinances and all that stuff is done on purpose to confuse people, to mislead people, to just bamboozle people, so you can never comprehend it. That's why they want you to be represented.
Well, not only that, they have their own special language called legalese.
Yep.
So, you know, and the way that they do it, for every case on one side, they have another one that decides it for the other. So, you know, which case is right? They're all opinions of men, cross-dressers, you know what I mean? Men and women that sit up there in their little black dress and try to rule the world. Well, you know, I mean, the way that the American people set up their justice system is, I mean, one of the best in the world. You get a trial by a jury of your peers. That means that, you know,
the people who
know you. You know, you if you've got, usually it's within a community, and so you got a couple of people within the community that are beefing. Well, back in the day, you know, the communities were like families. Sure, they had their beefs and stuff, but they were like families. Why? Because there was shit out there they had to be afraid of, that they had to watch out for. So, you know, they would come together and they would stick up for each other and they would fight and defend each other. So the communities were pretty tight, and they knew when strangers were in there, and I mean the whole 9 yards, right? And so, you know, it would be the people from that community that knew you, that you would go on trial, and the jury would actually be the ones that questioned you, not some lawyer with some, you know, silver tongue, you know. Nah, you know, your homeboys, your neighbors, your friends. Well, hey, you know, hey, Doug, why'd you do that? Why'd you bust that dude upside the head? Well, let's see. He was trying to break into my home, and all I could get was a log. If I'd had a gun, I'd have shot him. You know. Well, we find you innocent then, self-defense. No problem. You know, that's the way things are supposed to be. Things are cut and dried. You know.
Well, so this was our part 3, because we have this one to attend to. So guys, thank you for listening. Thank you for being patient. Make sure that you listen to the part 1, part 2 that you will find on Facebook and YouTube, and we will see you in the next video.